I agree with you wholeheartedly. There's been a tremendous amount of work by experimental psychologists. If you want to read both a readable, an extremely readable, I wish I could write as well as him, account of the development of this area, and one that really says a lot about policy, read James Doyle's True Witness. It came out only in 2005, but he really goes into it in great detail, and it's a book that's influenced me. Well, let me take that and segue in a different direction. Wrongful conviction has been known about for a long time. The notion that better 10 guilty people go free than one innocent be convicted goes back into the Middle Ages when the adversary system was being developed. It's in Blackstone. Jefferson mentions it. In the 20th century, there were a series of books that were written about wrongful conviction. Borchards' 65 cases of wrongful conviction in 1932. The guy who created Perry Mason, Earl Stanley Gardner, created something called the Court of Last Resort, where for a few years in the early 1950s he got together with some other people, and they actually took cases and got exonerations. And they tried to fund it by making it into a TV program for a while and selling it on magazines. That fell apart. Jerome Frank, who is one of the great leaders of sort of a law and psychology, legal realism movement in the 30s, towards the end of his life wrote a book called Not Guilty about cases of wrongful conviction with his daughter. There were several other books. And then in the mid to late 1980s, Bedeau and Radelet published a very famous article in the Stanford Law Review showing hundreds of miscarriages of justice in death penalty or death penalty eligible cases throughout the 20th century. So we know about it. But it wasn't until DNA testing that the system couldn't sort of brush the issues aside and say it rarely happens. Those cases you claim are wrongful convictions really aren't, because there are other facts that show you got it wrong. With DNA testing, suddenly it became very apparent that there was a problem. Now, how do things happen in the world, right? You know, it's like making babies. They don't just happen. How does it happen that we're actually talking about this as an issue? And it's not just something we read about, because there's all kinds of stuff that goes on that never gets to square one. Well, psychology is one field that perhaps is to some extent not given all the credit that it should be in criminal justice. One of my pet peeves with criminal justice, I could go on this at greater length with faculty members, is that I think that while perhaps the core of the disciplinary core of criminal justice, I think it's becoming a discipline, has to be in the methods and thought processes of sociology. I think we're a little bit too heavily weighted towards sociology in criminal justice. I think we need more people with backgrounds in political science, the policy sciences, as they're sometimes called. We need a sprinkling. We need a few more anthropologists, an economist or two, because this is a multidisciplinary field. Okay, policy analysis. How come an issue becomes an issue? People in criminal justice often are a bit clueless about it, or they analyze problems like the bizarre extent to which we criminalize drugs in this society and put several 100,000 people in prison, probably don't have to belong there. The sociologists in the field do a very nice job of analyzing the problem. They don't have a clue as to how to solve it. People in political science departments and pub ad departments really know how to deal with it. Okay. Before something is put on what political scientists call the policy agenda, there usually has to be some kind of movement. There's got to be some action that takes place that makes an issue that people in the legislature are willing to wake up to and deal with. So that's called putting an issue both on the social agenda, policy agenda, legislative agenda, governor's agenda, and the like. How did it happen? The first DNA exoneration in the U.S. was Gary Dotson in Illinois in 1989. Then they started to happen, and there were reports in the newspaper. Well, that's nice. That could still be the case today. A couple of things happened. First thing, people in power, people in politics, have a lot of discretion to make issues go forward or to slow issues down. If you want to read a really scary book, read Professor Willard Oliver's book about presidential agendas and criminal justice, and he shows how Bill Clinton really needed to sort of gin up some electoral juice after his program on health care failed in 1993. So being the skillful politician that he is, he turned on a dime and started talking about crime. And within a year, he turned crime into the #1 issue that people said they were worried about. I mean, we have a manipulative democracy. Well, you know, Alcibiades was able to manipulate the people of ancient Athens in the middle of the Peloponnesian War, so why shouldn't a skillful president of the United States with a silver tongue be able to manipulate people? And he turned this into a big issue. There was, I think, a pretty good crime bill passed in 1994. Then he forgot about the issue. Okay. His Attorney General, Janet Reno, noticed these DNA exonerations, and she turned to Jeremy Travis, who was head of the NIJ, who is now the president of John Jay College of Criminal Justice in New York, and said, this is a real issue. I want you to do something about it. So he paid some folks to do a report. I don't know if I have the report back here, but it's called something like Convicted by Juries, Exonerated by Science, and pointed to only 26 cases. That's a drop in the bucket, right? I mean, how many are there? 26 cases where people were found guilty mostly because of mistaken eyewitness identification, not because of police corruption, not because anybody was especially doing anything really bad, but because mistakes happen in the system. And that wasn't a heavy-duty research report. It wasn't the sort of thing that was going to get somebody a PhD. In fact, the report doesn't start until page 20, so it's front-loaded with responses by judges, prosecutors, lawyers, and police. And what Janet Reno was doing was holding this up to the criminal justice system and say, this is an issue. And then people started to walk with it and started to run with it. And then she had a commission, a task force that got together and produced guidelines on how to improve eyewitness identification, how to improve lineups so that errors will be reduced. Gary Wells, the leader of that program, estimates that by 1997, 2,000 articles had been published by experimental psychologists on lineups alone. And they had developed techniques such as the sequential lineup, where you see one person at a time rather than people lined up, and double-blind methods where the officer who runs the lineup doesn't know who the perpetrator is, as ways of reducing error. And I read a sheet to my class indicating that a bill was recently passed by the California legislature to implement these improvements and to videotape lineups, and Governor Schwarzenegger vetoed the bill. What? I feel like Jon Stewart all of a sudden, except I'm not funny and he is. He vetoed the bill? Well, I don't know. There were some politics there. Usually what happens is cops say, wait a minute, give us some time. It's too expensive. We really don't want to do it. That will probably pass in time. People in political science will tell you that issues rarely pass initially. The Justice for All Act that passed in 2004 was signed by President Bush, was kicking around the halls of the legislature for 5 years. But there's now a law where the federal government establishes minimum standards for DNA labs and provides money to the states if they will get their labs up to those standards.